Hello everyone. Today we'll explore the concept of coercion and its role with respect to consent in a contract. This topic will be covered by myself, Prithvik Medekar, followed by Bhumi Naik, Krupa Naik, and Pratiksha Patil. So, what is coercion? Coercion refers to the act of compelling or forcing someone to act against their will through the use of threats, force, or undue pressure. In legal language, it undermines a person's free will and decision making, making any resulting agreements or actions legally questionable. So, legally, under Section 15 of the Indian Contract Act 1872, coercion is defined as committing or threatening to commit any act forbidden by law or unlawfully detaining or threatening to detain any property to the detriment of another with the intention of causing that person to enter into an agreement. This essentially means that if a party is forced to sign a contract under threat or fear, the contract is voidable, meaning the aggrieved party has the right to either enforce or void it. Coercion is not limited to physical force, threats, or legal action or economic pressure can also constitute coercion, depending on the circumstances. Courts often assess the situation to determine whether consent was given freely or not.
Everyone, my name is Bhumi Naik, my roll number is 17, and I'm going to tell you some examples and case law on coercion. Coercion is when someone does something when someone threatens or make harm someone to do something. For example, when a bully threatens a person to give him his money. Another example would be when a shopkeeper threatens someone or customer to buy the product at the high price or otherwise they will harm him. Here the customer buys the product but without his consent. This becomes coercion. A case law on coercion with Raghunath Prasad versus Kalyan Singh 1957. Here Raghunath Prasad, the plaintiff, was threatened by Kalyan Singh to sign a contract in which Raghunath Prasad signed the contract without his consent. So the court held that a contract made under coercion is voidable. So Raghunath Prasad's contract was made under coercion. So the contract was void in the case. Thank you.
Hello everyone, myself Pratiksha, and in this video I am going to explain you all the various types of coercion. So before moving on to the main topic, let me just give you all an example to know what a coercion means. An example could be a boss threatening to fire the employer for not agreeing to work for overtime because they are not being paid. So the employer, out of fear of losing their job, they might agree to do so even if they are not being paid extra money for working overtime. Before moving on to the types, let's brief onto what a coercion is, as I have already given you all the examples. So now I am going to give a brief meaning. Coercion is the act of forcing someone to act against their will through threats, intimidation, manipulation, or also under pressure. Coercion is often unethical and in many cases illegal. It can cause long term psychological and emotional harm to the victim. Recognizing coercion is essential to protecting individual rights and freedom. Now, let's move on to the main topic, that is the types of coercion. There are various types of coercion, such as psychological coercion, physical coercion, economic coercion, and the others too. Now, let's begin to the main topic, that is physical coercion. Physical coercion is a type in which it involves using direct physical force, threats of harm, or restricting someone's movement to force them into submission. For example, a person locked into a room and not allowed to leave until they agree to do something. The next one is psychological, which is also known as emotional coercion. This type involves manipulating a person's emotions such as guilt, shame, fear, or love to control their actions. For example, an example could be a friend says that if you don't help me cheat on the test, I won't be your friend anymore. That is obviously a psychological coercion, because if you don't show them the answer, then they will obviously not talk to you all. The next one is economic coercion. That is a form of coercion uses financial threats or economic dependency to force someone into compliance. For example, a boss tells an employer, if you don't work extra hours for free, I will fire you. Moving forward to duress by imprisonment. This type of coercion involves restricting someone's freedom by imprisoning or confining them to force them to act. For example, a criminal holds someone hostage in their home, demanding that they carry out a task. Or also, another example could be a person is locked into basement and forced to sign a contract against their will. Moving on to the last one, that is duress by threats. This involves forcing someone to act by making threats that cause fear of harm to themselves or others. Example could involve a gang member tells shop owner, pay us money every month or we will destroy your shop. Or another example could be a witness is threatened not to testify in court, fearing for their safety. So these were some of the types of coercion. I hope you all liked and also understood what I spoke. Thank you for your time and attention. Thank you.
Hi everyone, I am Krupa Naik from first year BLLB and today we are going to discuss effects and remedies of coercion. When coercion is proven in a contract, the law steps in to protect the victim and restore justice. Under Section 19 of the Indian Contract Act 1872, if a contract takes place through coercion, then the contract becomes voidable at the option of the aggrieved party. This means the victim has the right to either cancel the contract, where the party who was coerced can reject the contract entirely, or enforce the contract without the coercive terms, where, if possible, the contract may be upheld without the part that involved coercion. Moving on, now let's discuss the remedies. Victims of coercion have legal option to seek justice, such as filing a lawsuit where a victim can approach the court to have the contract declared void. Second is restitution. The coerced party may be entitled to recover money or property lost due to the contract. And third would be criminal action. In severe cases involving threats, assault, or unlawful detention, the coercing party may also face criminal charges. A landmark case that illustrates this is Chikam Amiraju vs. Chikam Shishamma, a case from 1918. Here, a man threatened his wife and son with suicide until they transferred the property to him. The court ruled that suicide threats constitute coercion under Section 15 of the Indian Contract Act, making the agreement voidable. This case highlights that even psychological pressure can amount to coercion. In contract law, fairness is key. If a person is forced into an agreement, the law ensures they have a way out and a path to justice.